Good afternoon. I'm Ollin Sykes with Sykes and Company PA, along with Scott Sykes, a shareholder in our firm. We'll be joining Jesse Dresser with Frier Levitt in just a few seconds. But we wanted to first of all thank you very much for attending the Master the Margin series today, which is our attempt here at Sykes and Company to uh, talk to many of our vendors that we deal with in this particular industry. Sykes and Company, for those of you who do not know, works with pharmacies only, independent retail pharmacies all over this country. We're some 45 people. We have DME, specialty, regular independents, closed door, niches of all types. But it's our pleasure to facilitate this process today on a very important topic, dealing with DIR and GER fees, which is obviously a very, very hot topic in today's environment. So with that said, Scotty, you want to make a couple of comments before turning it over to Jesse?
Sure. Welcome everybody here today. We're going to touch on a lot of the bigger issues that are impacting the pharmacy legal side of things. I know I've got a list of questions here we're going to go over, but we welcome everybody. And Jesse, I'm going to let you take it from here.
Sure. So my name is Jesse Dresser. I'm a partner with the law firm Frier Levitt. We are a boutique healthcare life sciences firm representing a broad spectrum of healthcare and life science companies, ranging from doctors, hospitals, surgery centers, medical practices, pharmacies, including specialty, community, retail, compounding, mail order, and the like. We also represent other life science companies like wholesale distributors, pharmaceutical manufacturers, and other ancillary providers and service types. And in that, we kind of have developed a unique perspective, a unique niche in focusing on issues related to the healthcare life science community. My particular area of focus is on the pharmacy and drug channel, representing a broad cross-section of pharmacy providers, including retail, community, compounding, and specialty pharmacy providers. And in particular, focusing more on the relationship with the payer and general compliance in that space, and in particular the nature of the PBM relationship with the pharmacy. So it's as Scotty and Ollin have mentioned, this is a great topic, very near and dear to many of our clients' hearts, and it's the top legal issues affecting pharmacies every day, and in particular a focus on the payer and reimbursement related issues that we have kind of at hand.
And we'd also like to mention right up front here that as you have questions, as I'm sure many of you will have questions as we go along today, please don't hesitate to put those questions in. Our attempt here is to answer as many of those questions as we can as we go about to the course of the next few minutes in talking on this particular topic. And because we're dealing in this particular area every day as Jesse is from his angle, we just know many of you have just all kinds of questions about the particular area here. So with that said, why don't we just cover kind of the macro issue part of the process, Jesse? I think you had a really good slide that really covers that in generalities. If you want to just walk into that just a second, please.
Sure. So big picture, when we talk about the payer-related issues, so the first kind of question is what is the payer? And there's a kind of broad meaning of why that's important. And we can kind of go through this slide, which illustrates it well. So there are about 350 million people in the country. They all fall somewhere on this pie chart, every single one of them, whether they have insurance, whether they don't, whether they have commercial insurance, whether it's public coverage, they're all represented somewhere on this pie chart. So on this big green section we have on the right, that's the commercial space. That's the employer market. It includes large employer plans. That's clearly the biggest chunk of that. You have the small employer group market and public employee benefits. You also have in kind of darker green military, TRICARE, VA. That's kind of included on the employer side because technically it is a benefit of employment as a serviceman or woman in the armed forces. It's a benefit of being a service member. Then you have kind of the orange section, that is the Medicare. There are a couple different types of Medicare. There's traditional Medicare, Part A and B. There's Medicare traditional Medigap coverage, Medicare Advantage, which is also commonly called Part C. It combines a drug benefit with Parts A and B. And then there's a form of Medicare that's available to certain segments of people that are actually under 65, and it bleeds over into the red, which is the Medicaid. There are a couple different types of Medicaid programs, which in turn bleeds over into the blue. That is the Affordable Care Act exchange market, as well as the yellow, which is the individual insurance that can be bought either on exchange or off exchange. And then finally, we have this white here, which is the uninsured. Now, the reason that this is all important is each of these different sections have a different set of laws that apply to them. So you look at the orange section at the bottom, particularly from where we're focused on the drug costs. So they're basically two different types of coverage for drugs in the Medicare space that most retail pharmacies do. It's either Medicare Part D or Medicare Advantage, which includes a prescription drug plan. Every now and then there might be some products that get reimbursed on a Part B, as in boy side. That's typically infused products or home infusion products, may sometimes be covered as a Part B benefit. But for the most part, when we talk Medicare, we're talking Medicare Part D, and there's a whole set of rules, regulations, statutes that apply there. If we're talking about a Medicaid patient or Medicaid prescription, we're going to be looking at the red. That's going to be some federal rules, but largely a state-by-state kind of analysis. Then we look at the green. If we look at the green, there are a couple different little tranches within that, and it's important because those tranches are going to have different rules. For example, you look at the small employer group market, that's going to be largely the state laws that regulate insurance. That's typical traditional insurance. State rules are going to apply. You look at the public employees, sometimes states include them in the coverage of regular insurance. Sometimes they create specific rules around state public employee benefits plans. For example, North Carolina is one of those states that has separate rules as it relates to those public employee plans. And then that final big section there, that's the large employer group market, and most of that is self-insured, which means that state rules regulating insurance aren't going to apply because it's not insurance. It's just a plan sponsor that has enough patients and enough covered lives through it that they've decided, why pay an additional 12 to 15% premium? I'll just cover the claims myself. And so that's important because that means that those state initiatives, whether it's a state enabling provider law, whether it's a state rule relative to DIR, to MAC, those aren't going to apply. And so I always like to start with this slide because it gives good perspective, not only to understand where we're seeing some of these trends, like DIR, we see more heavily in Medicare space, NADAC, we see in the Medicaid space, GER, BER, we see a little bit more in the commercial space, and the reason really behind it is these different program rules that apply. The other thing I like to start with is kind of an overview of the pharmacy benefits landscape. So we start kind of with this concept of plan sponsors. These could be employers, could be union groups, could be government programs. They're essentially funding a plan that's going to include some drug benefit. They typically will then deal with health insurance companies either on an administrative services only basis, or usually in the case of small employers, will actually go out and pay premiums on behalf of their employees and buy insurance on their behalf. In turn, either the health insurance company or the plan sponsor will contract with the PBM to administer the pharmacy benefits. And so, for example, you might have a situation where an employer will pay premiums on behalf of their employees to, say, United Healthcare. United Healthcare will handle all the medical benefits, but in turn, United Healthcare hires OptumRx to serve as the pharmacy benefits manager to adjudicate all those claims. Now, we've seen in the past couple of years, there's been a lot of integration, a lot of mergers between health insurance companies and PBMs, so there's now kind of that vertical integration component going on. In turn, PBMs contract with a network of retail and specialty pharmacies. These can be independent providers, they could be chains, but more often than not, they also own and operate their own mail order and specialty pharmacies. And in the case of, for example, CVS Health, they own and operate their own chain of retail pharmacies. turn, the PBM also negotiates with manufacturers for rebates in exchange for formulary placement. Manufacturers through wholesalers sell to the pharmacy and supply the goods. And then in turn, the independent community pharmacies and the PBM-owned pharmacies compete to service those particular patients. At the end of the day, those patients are beneficiaries, whether they're employees, whether they're spouses of employees or dependents of employees, or whether they're beneficiaries of a government program, and in turn, they're looped into that plan sponsor. So that's kind of the big picture of the landscape. And I always find it good to start there because it kind of gives the lay of the land. It shows, I'm a visual guy, shows visually kind of how they all stack up against one another. And it's important to kind of keep that in mind as we start to talk through some of these phenomena that are occurring.
And Jesse, just looking here, kind of the big picture, one has to wonder how we got to this point over the period of years and decades that we've gotten into the healthcare system that we're in. And certainly the slide previous to this shows you how complicated the entire macro part of this arrangement is. But I think your benefit and landscape slide here certainly gives you a really good indication of what's really taking place within the industry. And so many people don't understand that PBM in the middle align with the manufacturers, align with the health insurance companies, the sponsors, et cetera, the PBM-owned pharmacies, et cetera, and the patients kind of being on the outside. Clearly, the patients have kind of clearly have been sucking wind over a period of time, which leads us to the discussion here we're having today, obviously about DR fees. So did all this really take place essentially because of what Congress did?
So it took place because of what Congress didn't do. The Congress, whether the state legislatures or the federal legislatures, really didn't have any grasp of what PBMs were up until very, very, very recently. And that was only because of the flack that another powerful industry was getting, the manufacturers. There was a time late 2017 and into 2018 where manufacturers were getting a lot of heat over drug prices. And they said, wait a second, you're pointing the finger at us because prices are going up. But if you look at the numbers, we're actually taking home less and less and less and less each year because we're being demanded to give more and more and more to PBMs in the form of rebates. And one of the things that we've been covering, because we've represented some other folks in this continuum, not just on the independent pharmacy side, we've also represented plan sponsors, including Part D plan sponsors, and we find that those rebates that are coming from pharmaceutical manufacturers aren't all making their way back to the plan sponsor. There's a lot of it that's being siphoned off and kept by the PBM. And so a lot of the reason why it looks the way it looks today and why we have some of these issues like DEIR and GER are the result of Congress being relatively slow to act to even acknowledge what a PBM is. We, as a litigator, we'll get before a judge, we'll spend 15 pages in a brief plus an hour of oral argument talking about the issue, educating them, and then the first question out the judge's mouth is, what's a PBM? These are Fortune 10 companies that the patients simply have no idea who they even are. They might know who their insurance company is, but I would venture to say fewer than 2 out of 10 patients even know who their PBM is. And the only reason that those 2 out of 10 do is because they've had some kind of run-in with them. So and that kind of takes it up to where we're at now and the importance of one, understanding these issues because one of the interesting things is while Congress is just kind of getting around to starting to regulate PBMs from a broad level, there have always been many, many tools available to independent providers to assert some of these rights and to protect some of their interests. And unfortunately, they just are simply underutilized by a large subsection of the community.
Mm-hmm. So speaking about today's environment, what we're looking at on the screen, where are you seeing things go, 2, 5, 10 years from now? As far as the PBMs are concerned in the industry as we know it today? Where do you see it transitioning in the future?
So there's another slide that I have that I didn't put on here, but it shows kind of the progression of what has happened with the different players. So if you look here, you see kind of in the middle, you have health insurance companies, PBM, PBM-owned pharmacy. At this point, At least the big ones, those are all collapsed. You have Cigna that just acquired Express Scripts, and Express Scripts owns its own mail order and specialty pharmacies. You have CVS Health that just acquired Aetna and already owns its chain of community retail pharmacies. And then you have Optum that is owned by United, has a mail order pharmacy, has acquired other pharmacies, and kind of scarily, they're kind of sending the next trend, which is venturing into the medical side. Optum being owned by United, they have complete visibility into how things are done on the medical side, and Optum has been slowly and quietly buying medical practices. There are over 100,000 doctors that work for Optum. It's pretty alarming when you think of being a patient and being in this kingdom. You're in this little fiefdom where you can only go to an Optum-owned doctor, you can only go to an Optum-owned pharmacy, you can only go to an Optum. It won't be long before it's an Optum-owned hospital. So it really casts a light on what that's going to look at, and it becomes very, very important at the independent pharmacy level to be aware of this backdrop going on and to be taking proactive steps to one, monitor your revenue levels, monitor to make sure that you're not losing money on each prescription, to monitor prescriptions that are being siphoned off or trolled or sucked away to a PBM-owned pharmacy. And going back to that first slide, pay as much attention to the nature of the benefit that the patient has as possible. Collect as much information as you can on every prescription, whether or not you're able to fill it, because over time you're going to be able to see trends. You're going to be able to say, wait a second, I'm only able to fill the first prescription for this particular plan, or I'm getting all these rejections for this plan, or this plan is giving me a $30 copay when it's $5 if they go to CVS Pharmacy. Whatever the case is, those are trends that the independent providers need to be cognizant of, because at the end of the day, those might add up into action. Those might add up into being able to leverage some of these tools we'll talk about to be able to equalize things a little bit.
So obviously, data being the key and big data being the term of the day, what can independent retail pharmacies do outside of collecting this information? Are there services? I know there are cloud-based services that help optimize inventory. There are cloud-based services that help optimize third-party receivables. But what can an independent retail pharmacy do to help collect this data and use it to their advantage, really in the real world?
So there are certain service providers out there, and I would encourage any independent pharmacy to speak with their computer software provider to get a sense of what their capabilities are. Discuss this issue with your reps. Talk about what it is that you want to be able to capture, the reports that you'd like to be able to run, the data that you'd like to be able to pull from that, and see what they offer and compare them. You might find that some might have better service when it comes to managing the fill process, but others might have much more visibility into that claims level and reimbursement level data. And I would encourage all the independent pharmacies to be aware of this and have that conversation when they're going through these processes with these different software and IT providers.
Mm-hmm.
And with the vertical integration that you touched on, and I know the CVS, I believe it's CVS Aetna deal that went through, and the courts approved it. That vertical integration, you would think at some point would be a conflict where there's no more competition. In other words, a monopoly of some sorts, and the courts didn't seem to rule that way. From your perspective, from a legal perspective, do you see that continuing? Is it ever going to get to a point where they say, time out, we can't, this deal can't go through, this is not conducive for competition in the industry?
So there are two things. The first thing is that generally these competition laws don't protect competitors, they protect competition. And so long as the big three can show that there's good, hearty competition between and among them, there's always going to be some level of a hook to be able to say there's still competition. Yes, three make up 85% of the market, but there's good, hearty competition between those big three so that consumers aren't harmed. That trope, that mindset is in the mind of the regulators, and until it can start to be shown that this level of consolidation has harm on patients and has harm on consumers, it's going to continue. The other thing that's important from this perspective is as we get more and more consolidated, and to that point, as more people kind of come to realize the individual harm that happens to them by virtue of this consolidation. When you start to have judges that have their own anecdotes and their own experiences of being forced to use a particular pharmacy, or you have the employers that start to become more savvy and realize, wait a second, I'm being shuffled around and I'm paying more and more and more, but I'm not getting anything for it, and I don't have any other option but to take this. That's when I think you're going to start to see change, but that can take time.
Yep.
And in the meantime, you still got to run a business. Independent pharmacies still have to run a business, and so I keep coming back to it in terms of maintaining a good pulse on what it is that you're going through, and coming to the plate and asserting your rights when it comes to it.
So that kind of leads directly into the conversation, and I think your next slide is if you want to flip over to direct and indirect remuneration, which we all know is DR fees. But obviously, in our environment, what we're seeing is those that have star ratings at or near 5 may have DR fees of about 2% or less of total accrued revenue. Those that have star ratings between 4 to 5, between 4 to 4.5. Sometimes those DR fees will run 3.5 to 4% of total accrued revenue. So we are beginning to see here for those independent pharmacies that are accounting for their DR fees correctly. And we probably need to have a brief conversation about that, Scotty, as well.
Yes.
Because so many pharmacies are not accounting for DIR and GER fees effectively. Let's just stop here and talk about that. When you get your electronic payments in from third parties and or your checks, your adjudication costs, DR fees, and GER fees typically have already been subtracted. And in your accounting system that you should be maintaining on an accrual basis in order to report properly what's taking place in that pharmacy, you've got to gross back up your revenue and show your DR fees, adjudication costs, and GER fees separately and distinctly in order to accurately report your gross margin correctly. And your gross margin on your financial statements for your independent pharmacy is the single most important number, we believe, in the pharmacy industry. Gross W-2 wages being number 2. But in order to be able to account for that properly, if you don't gross up your accounting books and records for these DR fees and adjudication costs coming out, then you cannot really tell what's taking place with your system. You'll be able to compare that and use that to your dispensing information coming from your script management system. So it's extraordinarily important that you are accounting for that first and foremost, so that you know exactly what percentage. Pharmacy is all about percentage as well as dollars. And of course, cash flow is king. But you've got to monitor and maintain and understand what those numbers are and why it's important and what you can do to affect that on your accounting books and records first and foremost before you can do anything else. So all that said, this piles into how the Aetna Caremarks of the world and related competition is pulling out these direct and indirect remuneration. And Jesse, do you want to kind of walk through that conversation just a little bit based on your slide here, please, sir?
Sure. So as Ollin mentioned, DIR is direct and indirect remuneration, and it really came into focus over the last, I'd say about 5 years or so. It's the concept behind it is really stems from rebates in the Medicare parlance, Medicare Part D parlance. They wrote into rules. They said, listen, if PBMs are going to go out and negotiate rebates on behalf of Part D plan sponsors, which are going to serve to lower the net cost of the drug, gross cost being sticker price, net cost being net after the rebate is received, we, being CMS, we want a share of that. We want to be able to receive some of that revenue that comes in from the manufacturer in the form of a rebate, so that we're not paying you based off of that higher cost of the drug. What happened was, in 2014, there was some proposed rulemaking that kind of clarified the definition of negotiated price and changed it from it being something that was that just was received after the point of sale to it being something that essentially wasn't known or knowable at the point of sale. So that meant that any rebate or any pharmacy fee that could reasonably be estimated at the time the claim was filled had to be passed along. And the reason that they wanted to do that is let's say for a $100 prescription, if it's $100 at the point of sale and the patient has to pay a 20% coinsurance, they're going to pay $20. Now, if 6 months later, the PBM gets $40 back from the manufacturer as a rebate, then the net cost is $60, and the patient has to pay 20%. The patient would much prefer to pay 20% off of $60 as opposed to 20% off of $100. So that concept came in. That's the whole gross to net bubble. The whole gross to net calculation that patients, in particular, those that have high cost products where they have a co-insurance, that's where they start to get concerned over that. So this rule change effectively made it so that PBMs had to come up with some basis so that they couldn't, quote unquote, know or should know the DIR at the point of sale. So that's when you started to see these performance metrics come into play, starting in 2016, because that's when the rule went into effect. In 2016, it started to have either variable DIR or DIR that was tied to some kind of metric that was measured after the fact. That way, the PBMs could make the case that they didn't know what the DIR would be. Now to your point, go ahead.
I was just going to say, from our experience, about less than half of the pharmacies actually are tracking their DIR fees. And I got a lot of questions this summer on the trade show circuit. Why do I need to be recording DIR fees? Why do I need to capture that? And you absolutely do need to be capturing this information in your books and records, because it's going to give you that accurate margin that Ollin was talking about, which is the key metric you need to be tracking. But it's also going to give you that data point of knowing how you're doing compared to your peers, what maybe is contributing to higher DIR fees. If you're above average, you're going to be able to see trends, et cetera, et cetera. So you absolutely should be getting DIR into your books and records, and if you are not, you need to get on that. Now,
there's another thing Scotty, sorry to interrupt. I want to just repeat that. There's another reason that's very important to be tracking your DIR, and that's because if at the end of the day you're in a position where you are being forced to lose money, and I'll go to my next slide. This will kind of show how it works in operation. But if you're in a position where you're being forced to lose money, that runs afoul of the any willing provider law. The federal any willing provider that applies to the Medicare Part D program says that terms and conditions have to be reasonable and relevant, that a PBM has to offer you reasonable and relevant terms and conditions. And there's guidance that says that paying underwater, substantially underwater, particularly, they use the example particularly on a specialty medication, but nevertheless, the principle is true if it applies more often than not. They're forcing you to lose money on the vast majority of your prescriptions, and the DIR might take what is a winning claim into a losing claim. That violates the law and is actionable. So here's two examples that I use kind of as illustrative purposes. There's two different types of DIR. There is the flat fee based, and these are typically an administrative fee. They range anywhere from $3.50 to $9 per claim. At least in my experience, they're assessed on every claim across the board versus percentage based. These could be network variable rates, network rebates, or performance fees. There's some that are less, some that are more, but typically around 3 to 9% of the cost paid on every claim based on certain performance criteria, and it's measured periodically with DIR fees now being deducted several months later. So we look at, a couple real world examples of how this plays out. Under both kinds. Under the flat fee based one, you take for example a situation where the acquisition cost is 150, the AWP is 180, adjudicated rate is AWP minus 15%. So you're looking at initial profit after acquisition of $3. Not terrific, but you're in the black. Now if they assess a $5 DIR fee on the back end, now all of a sudden you're underwater $2. And so if you're not tracking that, you're not necessarily going to realize that you've actually lost money and potentially substantial amounts of money in filling that claim. You look at the percentage base, and it could be even more significant. You could have an acquisition cost of 5,000, WAC of 5,150, so that after being paid WAC plus 1, you're looking at an initial profit of a little over $200. But if they assess a 5% DIR fee on the back end, you're going to wind up being underwater by $58 on the back end. So unless you're tracking this, you could be losing a significant amount of money just by filling these prescriptions. And so at the end of the day, that's where it becomes important to track this, because if you are losing money, those are some of those rights that I'm talking about. Those are some of the options that are available to pharmacies to be able to challenge some of this conduct. And we've had success working on behalf of pharmacies taking issue with PBMs over DIR fees, whether it's through negotiation or whether it's through some kind of legal action like litigation or arbitration. It's a slow process, but we have been able to work with PBMs to work with pharmacies against or with PBMs to improve the situation. Because at the end of the day, DIR fees are pervasive in the Medicare Part D landscape, and as a result, federal rules surrounding Medicare Part D apply, and so it's important to track these so that you can assert some of your rights if it comes to it.
What type of rights exactly does an independent have? Because I know we hear discussions constantly about these negative net reimbursements, and in CVS Caremark's perspective, they're on a trimester basis. In arrears. 4 or 5 months later, all of a sudden they're getting these clawbacks. What type of rights does a typical independent have to protect themselves?
So the biggest tool that independent pharmacies have is what's called the Any Willing Provider Law. The Any Willing Provider Law essentially says that any pharmacy willing and able to participate in terms and conditions applicable to other participating pharmacies must be allowed to participate. The federal Medicare Part D program has a Any Willing Provider Law written into the statutes. About 26 states have some version of an Any Willing Provider Law written into their books. Now, importantly, the federal government has interpreted terms and conditions to be reasonable and relevant terms and conditions. And so at the end of the day, if you have a PBM that's offering a Part D network that doesn't have reasonable and relevant terms and conditions, for example, it pays underwater on the vast majority of claims, or it pays underwater on a high cost product that is difficult to acquire, forcing people to float money that they're ultimately going to lose, that is an unreasonable term and condition. Likewise, there's a prohibition on irrelevant terms and conditions. So there are certain PBMs that have DIR fee programs that measure pharmacies on criteria that might not be applicable to other pharmacies. For example, you might be measured on diabetes adherence, and you might not do a single diabetes prescription. So how is it at all relevant to measure you and in turn assess money against you based on a framework that you have zero claims that's completely irrelevant to you? This becomes even more relevant in the case of specialty pharmacies. For example, specialty pharmacies that don't do the typical retail lines of business aren't going to have claims that fall into a lot of these other types of measurement criteria categories that are more applicable, more geared toward the retail pharmacy space. So at the end of the day, if you're having money taken back from you and it's not relevant and not tied to services or products that you're actually dispensing or could even influence you, that's the big key is being able to move that marker. It's impossible, or if there's no data or you're just not in a position at all to being able to move that marker, then it's not a reasonable term and condition. It's not a relevant term and condition.
Mm-hmm.
And so based on that, that's where we've been able to assert some rights on behalf of independent pharmacies.
We've got a question here. Any advice on mitigating GER fees? Of course, we haven't mentioned really what a GER fee is. You might want to first define that and discuss how
Sure.
that comes about, please.
Yeah, it's good a time as any to transition. So GER, generic effective rate, and there's another concept, BER, brand effective rate, and we've even seen just ER, effective rate. And what it is, it's technically a form of DIR in that it comes after the fact. You know, it's assessed after the point of sale. It's measured typically retrospectively and carried out retrospectively. The way it works is the plan will set an average aggregate network discount on generics or brand drugs. Let's say AWP minus 85%. And on a network level, they will say, of all the generics that are dispensed on this network, we are going to have an effective rate of AWP minus 85%. That means that some might reimburse at AWP minus 50, some might reimburse at AWP minus 90. But at the end of the day, after you weigh it out and you do the entire math, it should run at an effective rate of AWP minus 85%. It comes into implementation in connection with MAC pricing. So MAC pricing is the maximum allowable cost. It's the most that a plan will pay for a particular drug that has generic competition. If you look at this next slide, this is a good illustration of kind of how that looks. So there might be five versions of a particular generic that are available. These are all the acquisition costs, okay? Let's assume that the PBM sets a MAC price of $19. That means if you buy drugs 4 and 5, you're going to lose money. So pharmacies in turn, theoretically, are going to be pushed to buy drugs 1, 2, and 3. And that's assuming drugs 1, 2, and 3 are available in the marketplace and aren't on back order or aren't discontinued, which sometimes PBMs have been known to do, include prices from drugs that are not available or discontinued, and use that to set their MAC price, and so it's completely irrelevant to actual acquisition costs. As a result, many states have passed MAC rules that prohibit PBMs from setting MAC pricing where there isn't examples of actually available product that can be sourced for below that MAC price. And that's important too, because as you see how this kind of plays out, it's one of those rules that was passed by many states in order to the benefit of independent pharmacies, to give them the ability to submit an appeal when they're getting paid less than what they bought it for. But this GER has become kind of a tool for PBMs to try to circumvent some of those requirements. So here, you look at those products, they might all have different AWPs. So some might have, if you look at it, an AWP discount of 80, some might have an AWP discount of 88. It's all because AWP is not necessarily consistent based on acquisition cost. And so the issue becomes that, let's say if a plan sets a GER of AWP minus 87%, and a pharmacy filled too many of these products here, the ones that were, if we go back to the other slide, were below the MAC price, but don't have as steep of an AWP discount. It's only AWP minus 84 for one and AWP minus 86 for the other. They could find themselves on the wrong side of it, and so there has to be some kind of true up, some kind of clawback from that pharmacy or from a particular pharmacy group of pharmacies to be able to make it whole. Because at the end of the day, the PBMs have claimed that they have their own GER obligations to plan sponsors. And so they might contract with a network of pharmacies for GER discount of AWP minus 87%, but meanwhile have an obligation to deliver to a plan sponsor an average GER discount of AWP minus 84%. And that 3% spread is going to be their vig. It's going to be their commission, so to speak. But they need the pharmacies to hit their numbers so that they in turn can hit their numbers with their plan. In fact, a lot of pharmacies that are doing single source generics, generics where there might not be as a result of consolidation or as a result of ceasing production, there might not be a lot of alternatives, and as a result, those typically aren't going to be matched because they aren't multi-source generics. So instead, they'll be paid at the standard generic rate, which might be, let's say, AWP minus 25, 26%. But if you have a GER rate of AWP minus 87%, you're ways off from what that number is going to be. We see this enforced a lot at the PSAO level. So it's important too, when you're negotiating or entering into PSAO arrangements, you're very clear on how the PSAO handles this type of accrual, because what the PSAO will typically do is they'll run their own projections month over month to get a sense of where they're at. And if they feel like that they're running too low, they might proactively make a clawback or a withhold from pharmacies, just so that they're not left in a lurch where all of a sudden you get a bill for $5 million and have to pay it in a week. I've seen that happen where a PSAO gave a pharmacy a bill for $5 million and said, this is coming out of your reimbursements starting next week. And we had to file a lawsuit and seek a TRO to stop it, because at the end of the day, they don't want to be left holding the bag. But if the PSAO isn't giving proper notice to the pharmacy, it can become a real problem.
Yeah, and we've seen that too in a number of cases on some very large numerical dollar terms. And I know you guys have helped several of our clients in that process. Let's change direction here just a second. We got a question that's come in, Jesse. Let me just read the question while you take a little break there. This question says, I've recently heard that plans are required to submit a DIR report to CMS before reconciliation adjustments are made that include both pharmacy DIR and DIR for manufacturer rebates. How does this work, and how can CMS make sure the PBM plans are actually reporting accurate DI information to them?
So it is true that plans have a legal obligation after the plan year to accurately report DIR from all sources. That includes rebates. That includes certain fees that are received from manufacturers. That includes DIR fees assessed from or paid to, kind of a joke, DIR fee paid to pharmacies, but nevertheless, it's a category that they have to report after each plan year. Typically, the way it works is plan years run from January 1st to December 31st, and by about June, July, that's when they have to submit their DIR reports to CMS, listing out all the DIR. Now, those are required to be accurate. They have to sign attestations that they're accurate, but it doesn't change the timing of when they can recoup those funds from the pharmacy. And so the way some of these work, a couple different ways that DIR is taken out. Historically, DIR would just be taken out at the time you got paid. So you submit a claim. You submit a claim on January 2nd. And it's for $100, it adjudicates for $100. You expect to get paid $100, but then when you get your payment, it's only $95 because there's a $5 DIR fee assessed on that claim. So it becomes easy from a cash perspective, where you're not accounting for cash that you're ultimately going to have to give back because you never received it. You never received that DIR. And it's only a 2-week period of time, typically, between when you submit a claim and when you get paid for it by the PBM. That changed with that rule change I mentioned, the 2014 rule change, where it started to be drawn out a bit, where there were DIR fee programs where you would submit a claim on, let's say, January 2nd for $100, it would adjudicate for $100. Then on June 1st, they would start a retrospective measurement period looking at claims from the first quarter or first trimester of that year. They'd ascribe a score, and then starting July 1st, they would start taking out that money, so that you could be having money taken out from you in August for claims that were submitted in January. And in turn, there'd be a tail, and you'd wind up having money taken out, next year for claims that were submitted last year. So that's kind of how it's worked at the pharmacy level, and there have been a couple high-profile instances of pharmacies that were alleged to have done a poor job accruing for that contingent DIR liability. There was even a couple public settlements on that score by pharmacies over that issue. But that's kind of the way it functions now, and it's not really tied to the report that the plans have to give to CMS. They do have to send a report to CMS, but it's not the timing of when the DIR is taken back from the pharmacy isn't linked to when those reports go in.
Yeah.
So what do you see as far as trends with DIR, GER, BER? I know from our perspective, we've seen DRs, et cetera, trending up each and every year, of course, as transparency has also been has come through on the 835s. They're able to capture that information. Where do you see it going in the future?
So let's start with GER. GER is going to be the next big thing. It's only, in my estimation, it's only going to expand. It's only going to get more aggressive. It's being done, take it or leave it, by PBMs. It's more prevalent in the commercial space, although I have seen some of it in the Medicare Part D space, but it's becoming very, very prevalent in the commercial space. And it's extraordinarily opaque. It's extraordinarily difficult for pharmacies to be aware of these things, especially if they're contracted with a PSAO. Normally, if you have a relationship with a payer and they're going to pay you a certain rate, and all of a sudden, they're saying we're going to pay you an effective rate, and they pay you less than what you think it ought to be. Theoretically, you have some ability to challenge them, to either conduct an audit or to object or voice your concern. With a PSAO, all those rights are held by the PSAO. So if the PSAO doesn't object, if the PSAO doesn't audit, if the PSAO doesn't review it, and they just say, okay, thanks for the bill, as their attorney, as your agent, as your attorney, in fact, they have, you're kind of stuck with it. That's what you got. You don't really have a tremendous amount of leeway in terms of pushing back against the PBM under that contractual term. So, for that reason, I see GER kind of expanding and it becoming very, very important for pharmacies at the time they're entering into contracts and as they're undergoing those relationships, to be able to fully understand what their reimbursement rates are and how they can impact them. As for DIR, there are several pushes from both a regulatory standpoint by CMS as well as from a legislative standpoint to try to rein them in. But at the end of the day, PBMs have a very powerful lobby. And so if there is going to be any kind of success, it's certainly going to take time. I mean, DIR has been an issue now for over 3 years, and we still haven't seen any kind of legislative or regulatory relief. We've seen a couple efforts that were pulled back. So the only thing that I think will start to rein in DIR is the movement from the patient standpoint, where they're able to show that their particularly specialty patients are paying substantially more out of pocket than what they could have paid if the discount had been applied at the point of sale. But I've seen DIR proliferate and grow heavily over the past couple of years. And the biggest check that I can say, biggest check and balance to DIR that I can recommend to any independent pharmacy is to evaluate how they're being treated under it, and to know their rights and to use them. That's going to be the swiftest and most direct way of achieving any kind of relief in this capacity.
So in that regard, Frier Levitt's role as far as working directly with independent pharmacies, we've got just a few minutes left here. Want to get everybody back to work. But what do you see primarily as what you guys can do to help, whether they're specialty, a typical independent, one that feel like they're being attacked rightly or unjustly with all these clawbacks? What does your firm do to help, or what kind of services can you provide other than some of these specifics that you have mentioned. Any other types of things that you guys do to help our folks that are out there?
Sure. So, it ranges all the way from the basics to helping to understand the nature, extent of the problem. We know the questions to ask. We know the pieces of information to look at. We know the metrics that need to be considered, and we can evaluate the extent of your problem and what some of those rights would be. And we've even offered to do that in many instances on an alternative fee or flat fee arrangement basis, where you're not being stuck with an hourly bill. We're able to do it efficiently and be able to deliver it in kind of a predictable manner. That's kind of the basic one. But from there, under your contract, you have a lot of rights. Whether it's going to a good faith dispute resolution provision, whether it is going to mediation, whether it's actually going to litigation or arbitration. There are a lot of rights that are available to pharmacy providers under those contracts. One of the things that we could do is start by writing a demand letter and getting the process moving. And it's one of those things that if there is a sea of people looking into this, if there are challenges, they're going to react in some capacity. The other thing that we've done is explore, rather than doing direct claims against PBMs, there are other options to kind of raise the profile of this, both with regulators and with lawmakers. We've worked with folks to educate their local and both federal and state representatives about these types of issues. We've also communicated with regulators like CMS or State Department of Banking and Insurance. A lot of things that providers have at their disposal, that particularly if all 100 people on this webinar did, it's going to start a ball rolling. And they do it, and then they get 2 more people to do it, and each of those 2 people get 2 more people to do it. That's how these things evolve and how change occurs. But it starts with kind of going back to that basic understanding the nature, extent, and degree of the problem and harm that you're facing.
Yeah. I got one quick question here. So a lot of issues we see with 340B contracts is DR fees are never addressed in those contracts, and the pharmacies sign those contracts with no clue on who's responsible for the DR fees, etc. Can you just touch on that for what's some things pharmacies out there need to look for, best practices with how that's concerned?
Certainly, and I agree that is a big issue that has come up in the context of 340B relationships where pharmacies serve as a contract pharmacy. Many of these contracts are silent as to DIR.
Yeah.
And your best case is that you can throw in enough nets in there to make the case that, look, if they're going to net it out after the fact, the money's got to come back. But the difficulty is that the administrators are typically hired by the 340B covered entity, who are going to answer more to them and less to you, the contracted pharmacy. And so it's certainly important that at the time of negotiating the contract, you have a frank discussion about it. But 2, you're also aware of what your rights are under that contract, whether it's audit rights, whether it is a reconciliation right. We have assisted pharmacies in basically saying we need a reconciliation to the tune of $150,000 because that's how much DIR was taken out on behalf of your claims over the last year. And I've worked with covered entities to true it up in certain instances. So it's definitely something that's certainly at the time of contracting, but even if you're under contract, to understand what's in there and to make sure that you're not sitting on or losing your rights.
Absolutely, and I think it's fair to say we run into this quite frequently, that if a covered entity is presenting to you a 340B contract to sign, if you don't have professional representation to assist you in either writing that contract or making sure that you understand all the provisions in that contract, you're signing a death warrant from what my experience has been. That said, these contracts can be a win-win for all involved if properly structured. So just be very careful if everyone is presented to you by any covered entity that you are getting professional representation and make sure that you've got that covered. Jesse, I don't see any other questions here. I think we've got them all answered. If you don't mind flipping to that next slide here, we'll kind of wrap it up here, coming up here on the hour. we appreciate everybody's attendance today on this call. Again, it's our attempt to further educate independents that are in this space. We're all working in this space day in and day out, and we have a lot of resources, as does Frier Levitt, on websites. In our case, we literally have hundreds of videos that we have produced and continually update about every 10 days. We would invite you to take a look at what's in the public domain that we have out there, and to sign up for our YouTube channel. Also, we have our direct numbers and access information here. Again, our firm provides cloud-based accounting services to independent retail pharmacies only, all over the country, tax mitigation and tax compliance work for these independent pharmacies. So we provide that advice and counsel that is needed without any conflicts of interest. There's no conflicts of interest in this call today. And Jesse, that'll wrap it up from our perspective. And any comments you want to make here and wrapping it up from your end?
Again, thank you guys for having me. This was great. And the other thing I'll mention, along with Sykes, is we do a lot of things on alternative fee arrangement bases, particularly in the independent community retail space. Whether that's a flat fee, whether it's a success fee or contingency fee basis, ranging from putting together policies and procedures, looking at kind of a legal audit of your operations, to even potentially certain types of litigation, whether it be over audit recoupments, whether it be over payment issues, network access issues, whatever the case is. I'll also make a quick plug. I have one of my associates will be at NCPA in the end of October, so be sure to check in there and talk about some of the things that we've done on behalf of independent community pharmacies.
Absolutely. We appreciate you being with us today, Jesse. We also will be at the NCPA convention, be speaking several different times, and at the ownership workshop. And we look forward to seeing you. Please stop by our booth. And Scotty, anything you want to say here as we wrap up?
Nope. Appreciate Jesse, but it looks like there are a few questions out there, and we will answer those via email for those we didn't get to.
All righty. Thank y'all very much for attending the webinar. Have a good day.
Bye-bye.
Bye-bye.